Hello everyone. Welcome back to our channel, Canada Immigration. We hope you're doing great. In this video, we're going to talk about surge in Canada immigration refusals, fueled by IRCC errors. Canada is facing a sharp increase in immigration refusals, with a growing number of cases linked to processing errors by Immigration, Refugees, and Citizenship Canada. Applicants and legal experts are raising concerns over inconsistencies, technical flaws, and unjust rejections affecting families, workers, and students. If you are interested in this topic, please pay attention and watch the video through to the end to get all the information. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. So, without any further delay, let's jump into the video. Canada has long been a beacon for immigrants seeking better opportunities, world-class education, and a vibrant multicultural society. Recently, Immigration, Refugees and Citizenship Canada has sharply increased refusals for visitor visas, study permits, post-graduation work permits, spousal open work permits, and even permanent residency applications. Latest available official data suggests that IRCC has achieved a 61% increase in refusals for high-risk countries. Many of these refusals also stem from errors made by IRCC officers, leaving applicants frustrated, anxious, and often financially burdened. This video dives deep into the reasons behind the rising refusals, the impact of IRCC's errors, and actionable steps you can take if your application is denied. Why are immigration refusals on the rise? The surge in refusals across various Canadian immigration streams, visitor visas, study permits, PGWPs, SOAPs, and PR applications has sparked concern among applicants and immigration professionals alike. But what's driving this trend? 1. Overwhelmed IRCC systems. IRCC usually has nearly 2 million applications under processing at any given point in time, and the sheer volume can strain resources. Overworked visa officers may overlook critical documents or misinterpret eligibility criteria, leading to erroneous refusals. For example, an applicant might submit sufficient proof of funds, only for the officer to claim otherwise due to oversight. 2. Policy changes and stricter requirements. Recent policy shifts, such as tightened eligibility for SOAPs, effective January 21, 2025, and stricter scrutiny of study permit applications, have made approvals harder to secure. These changes often catch applicants off guard, especially if they applied before new rules took effect but were assessed under the new stricter guidelines. 3. Inconsistent decision-making. Visa officers have significant discretion in assessing applications, which can lead to inconsistent outcomes. For instance, one officer might approve a PGWP application despite minor gaps in documentation, while another might refuse it outright with perfect documentation. This lack of uniformity fuels perceptions of unfairness. 4. Miscommunication and procedural errors. IRCC's refusal letters often lack detailed explanations, leaving applicants confused about why their application was denied. In some cases, procedural fairness letters are sent in error, or applicants are asked for unnecessary documents, as seen in cases where valid language test results were overlooked. There were even instances where IRCC issued PFLs to immigration representatives instead of applicants, which was sort of weirdly reported by many consultants. 5. Rising application volumes. As Canada remains a top destination for students, workers, and immigrants, application volumes have soared. This influx can lead to rushed assessments, increasing the likelihood of mistakes. For example, a PGWP applicant might be refused for non-compliance with study permit conditions, despite maintaining full-time student status. In this case, the applicant is not at fault, but the IRCC officer is, despite the applicant meeting all the requirements. The impact of IRCC errors on applicants. The consequences of an IRCC refusal can be devastating, both emotionally and financially. Applicants often invest significant time, money, and hope into their Canadian dreams, only to face unexpected setbacks. Here are some ways refusals affect individuals. Emotional toll. A refusal can cause stress, anxiety, and uncertainty about one's future in Canada. For international students, a PGWP denial might mean losing the chance to gain critical work experience, a stepping stone to PR. Financial burden. Reapplying requires new fees, and pursuing judicial reviews can cost thousands in legal fees. For example, a judicial review at the Federal Court of Canada involves a $50 filing fee plus substantial lawyer costs. Lost opportunities. A refused study permit might delay or derail academic plans, while a SOWP denial could prevent a spouse from joining their partner in Canada, straining relationships. Immigration setbacks. Repeated refusals can harm an applicant's credibility, making future applications more challenging. For express entry candidates, losing comprehensive ranking system points due to age or expired documents can jeopardize PR eligibility. Common reasons for refusals across immigration streams. Understanding why applications are refused is the first step to addressing them. Below, we break down the most common reasons for refusals in each category, based on insights from immigration experts and IRCC guidelines. 1. Visitor visas. Insufficient proof of intent to leave. IRCC requires applicants to demonstrate they will leave Canada at the end of their authorized stay. Weak ties to the home country, such as lack of employment or family, can lead to refusals. Inadequate financial support. Applicants must show sufficient funds to cover their stay. Missing or unclear bank statements often trigger refusals. Incomplete documentation, missing travel history or unclear identity documents can raise red flags about admissibility. 2. Study permits. Questionable program choice. If IRCC doubts the relevance of the chosen program to the applicant's career goals, the application may be refused. Financial insufficiency. Applicants must prove they can cover tuition, living expenses, and return travel. Inconsistent or outdated financial documents are common pitfalls. Previous non-compliance. Violating study permit conditions, such as working unauthorized hours, can lead to refusals. 3. Post-graduation work permits. Non-eligible programs. Not all programs qualify for a PGWP. Private schools or programs shorter than 8 months may lead to refusals. Expired study permit. Applying for a PGWP after a study permit expires, without maintaining status, is a frequent cause of rejection. Unauthorized work. Working more than 20 hours per week during studies or before enrollment can result in a refusal. Incomplete applications, missing transcripts, proof of graduation, or other documents can lead to denials. 4. Spousal open work permits. Insufficient proof of relationship. IRCC may question the validity of a common law or spousal relationship if documentation, e.g., joint leases, photos, or declarations, is weak. Ineligible sponsor occupation. Post-January 2025, SOWP eligibility is restricted to spouses of workers in TER 0, 1, or select TER 2/3 occupations. Applications submitted before this change but assessed later may face errors. Procedural errors. Officers may overlook evidence, such as a valid declaration of common law status, leading to unfair refusals. 5. Permanent residency applications. Incomplete documentation, missing language test results, police certificates, or proof of work experience can lead to refusals. Misrepresentation. Providing inaccurate information, even unintentionally, can result in a refusal and a 5-year ban from applying. Low CRS scores. For express entry applicants, failing to meet the minimum CRS score cutoff can lead to rejection. Your options after a refusal. What can you do? A refusal is not the end of the road. Depending on the circumstances, you have several options to pursue. Each comes with its own benefits, challenges, and success rates. Below, we explore the 3 main pathways: reapplying, requesting reconsideration, and seeking judicial review. 1. Reapplying. What it involves: submitting a new application with updated or corrected documents to address the reasons for refusal. Pros: no waiting period for most applications, unless specified in the refusal letter. Opportunity to strengthen your case with additional evidence, such as updated financial statements or a stronger letter of explanation. Often the most practical option for study permits and PGWPs, especially if the refusal was due to missing documents. Cons: requires new application fees, which can be costly, e.g., $150 for a study permit, $155 for a work permit, plus $200 for restoration if applicable. Not viable if eligibility has lapsed, e.g., PGWP applications must be submitted within 180 BOF graduation. Risk of repeated refusals if the same issues persist, potentially harming future applications. Best practices. Request Global Case Management System notes to understand the officer's reasoning. These notes provide detailed insights into why your application was refused. Address all refusal reasons explicitly. Example: a PGWP applicant was refused because IRCC claimed their program was too short. After obtaining GCMS notes, they discovered the officer miscalculated the program duration. They reapplied with course schedules proving a 12-month program, and the application was approved. 2. Requesting reconsideration. What it involves: submitting an informal request via IRCC's web form or email, asking the visa officer to review their decision due to errors or overlooked evidence. Pros: no fees or specific forms required, making it cost-effective. Can be pursued alongside other options, such as reapplying or judicial review. Suitable when there's clear evidence of an IRCC error, such as a misread document or failure to apply a temporary public policy. Cons: low success rate, as officers have significant discretion and may not review new evidence. No formal appeal process, so outcomes are unpredictable. No strict timeline, though submitting within 30 days is recommended. Best practices: write a clear, concise letter outlining the error, e.g., the officer overlooked my valid language test results submitted on date. Include supporting documents, but note that IRCC may not accept new evidence. Reference relevant policies or case law, such as temporary public policies for PGWP extensions. Example: an applicant was refused a PGWP extension due to a 90-day restoration period issue. By citing a 2022 temporary public policy allowing extensions beyond 90 days, they successfully had their case reconsidered and approved. 3. Judicial review. What it involves: filing an application for leave and judicial review at the Federal Court of Canada to challenge an unreasonable or procedurally unfair decision. Pros: can overturn a refusal if the court finds the decision was legally flawed or unfair. Often leads to settlements, with IRCC agreeing to reassess the application. Suitable for complex cases or multiple refusals where reapplying isn't viable. Cons: expensive, with legal fees often exceeding thousands of dollars, plus a $50 filing fee. Lengthy process, taking 1 to 6 months for a decision, with the entire process potentially lasting over a year. Strict deadlines: 15 days for in-Canada applications, 60 days for outside Canada. No guarantee of approval, as the court only reviews the decision-making process, not the application itself. Best practices: demonstrate clear errors, such as procedural unfairness, e.g., not receiving a PFL, or unreasonable assessments. Avoid submitting new evidence, as judicial reviews focus on the original application. Example: an SOWP applicant was refused because IRCC questioned their common law relationship, despite ample evidence. A judicial review revealed the officer ignored key documents, and the application was sent back for reassessment. The call for IRCC accountability. The rising refusal rates and frequent IRCC errors highlight the need for systemic change. Applicants deserve clearer refusal letters, consistent decision-making, and fair processes. Here's what needs to happen. Transparent refusal reasoning: IRCC should provide detailed explanations in refusal letters, not generic statements, to help applicants address issues effectively. Improved officer training: enhanced training can reduce errors and ensure uniform application of policies. Streamlined reconsideration process: a formal reconsideration mechanism with clear guidelines could improve success rates and reduce reliance on costly judicial reviews. Accessible GCMS notes: making GCMS notes easier to obtain would empower applicants to understand and address refusals. Turning refusals into opportunities. A Canadian immigration refusal can feel like a dead end, but it's often a detour. By understanding the reasons behind rising refusals, addressing IRCC errors, and exploring options like reapplying, requesting reconsideration, or pursuing judicial review, you can keep your Canadian dream alive. Prevention is key: submit thorough applications, follow IRCC guidelines, and seek professional guidance when needed. The growing number of refusals and IRCC errors calls for systemic reform. Applicants deserve fair, transparent, and accountable processes. Until then, arm yourself with knowledge, stay resilient, and take decisive action to overcome setbacks. Is a reconsideration request worth it? It's a low-cost option but has a low success rate unless there's clear evidence of an IRCC error. How long does a judicial review take? The process can take over a year, with decisions issued 1 to 6 months after the hearing. As immigration continues to shape Canada's economic and social landscape, the surge in IRCC-related refusals demands urgent review. Without reforms and accountability, trust in the system could erode, leaving countless hopeful applicants in limbo. That is all for today, in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later, in the next video. Till then, take care.